Okay, we're going to make a very big turn in our discussion toward arbitration versus litigation for resolution of employment disputes. Ron is now going to lead off for 5 minutes, and Ann will have the next word.
In about 1991, when they began counting these things, and it was determined that there are roughly 18 million legal proceedings initiated in our courts each year, overwhelmingly involving employment-related issues. An alternative was being sought to the expense and the disruption of what we call litigation, what takes place around the courthouse usually. But it was difficult because there was no established alternative to going to court when you couldn't resolve your disputes by negotiation. What emerged from all that dust was a Supreme Court decision in the Gilmer case, 1991, holding that if you have an age-related claim, you can be required to arbitrate that claim before it arises. A pre-dispute commitment to how you're going to resolve age-related claims was deemed enforceable. That was a tremendous change, a sea change, in how age-related claims could be resolved if the parties negotiated for that purpose. About 10 years later, it was decided by the Supreme Court again that that issue was no longer limited to age-related claims, but all manner of employment-related disputes could be subject to an agreement before the dispute arises as to its resolution, not in a courtroom, but in the arbitral proceeding. The idea being, it's not public. Nobody gets access to that file by going to a courthouse and paying a photocopying charge. Less likely to be driven by media concerns who can't enter the arbitration venue. It's typically less expensive. It's often shorter toward resolution. The peril was and is that the arbitrators don't always respect the rules of evidence. And that means what might not find its way into a courtroom as evidence is often seen and read by the fact finders in arbitration, who are the arbitrators. If they make a mistake in applying the law, that's not typically reviewable. Unless they showed a manifest disregard for the law, the fact that they misapplied it doesn't necessarily mean on appeal, very limited, it'll get reversed. So defense counsel particularly are often cautious about committing significant issues to the arbitral forum. And then, of course, if the arbitrators have a bias in the employment context, because maybe they had their own unfortunate experiences, they're not just one juror among 6 or 8 or 12. They have much more weight with respect to the determination. And finally, arbitrators often, especially these days, reappear. They do this for a living. It's not the public service it once was. So they're more often to act like mediators seeking common ground in a resolution as opposed to making very, very difficult decisions. Now, just some months ago, the Supreme Court completed what some people call the row of 5 cases, others the trilogy, in finding that in the consumer context, you can even prevent an individual by agreement from ever representing or participating in a class action. 2 days ago, one of our judges here in the Southern District, Judge Kimber Wood, disagreed with that holding and said it was, in her view, in the context of a wage and hour dispute, a contract of adhesion, meaning you're forcing a point of view that was contrary to public policy on an individual employee who has an imbalance in the process of negotiation. Law right now is not as well settled as we'd like, but if the Supreme Court decision in Concepcion continues to gain traction, notwithstanding Judge Wood's disagreement, and it is possible, in fact, in the view of most courts, to say at the time of employment, you must sign this agreement now so that all manner of disputes will be submitted to arbitration and you may not lead or join a class action, That will also be a sea change.
All right, I doubt that we're going to hear much disagreement on that very last point. That would be a sea change. But we might hear some alternative viewpoints nonetheless from Ann Vladeck.
I'm surprised how much I agree with Ron on the perils of arbitration. But just to give a little history, when Title VII was first enacted, first of all, sex was thrown in as a way of defeating the bill by a Southern senator. So you know how much people cared about sex discrimination in those days. But it was primarily a statute aimed at race discrimination. And it was the cases that were brought under Title VII were to be brought to the court, not to a jury. And the purported belief at that time was that no Southern jury would find for a black plaintiff in an employment suit. As it became clear that Southern judges were really at an employment law peril, the plaintiff's bar lobbied very hard to get the jury trial for Title VII cases, and that happened in 1991. What employers have done, I know you're a lot of employers, but I think you're also employees, and one of the things that happened is that there was a way around that, and there were pre-dispute arbitration agreements that required people like Amy, who signed an agreement coming into a job that said up front, I waive my right to a jury, and I agree that any dispute will be decided by arbitration. That's a huge right to give up. And I think that part of the problem is that arbitrators know that their decisions are essentially not reviewable by any court with any meaningful way. So they give lip service to the law, if even that, and move on to deciding what they want to decide. Now, just to make it clear, that's when you sign an arbitration agreement before there's any dispute, when the honeymoon is still going on. I have no problem with people deciding once they have an issue, once they have a dispute, going to mediation, going to arbitration, and that's an issue that I think we can agree can very often work.
I find it really interesting that those who represent organized labor and commit themselves to resolving disputes pursuant to collective bargaining agreements oppose any effort to get out from under that agreement and let those individual employees bring lawsuits against the union or against the company if subject to a grievance apparatus that they negotiated before the individual might have been hired. That seems to be okay.
But that's so different.
But if an executive comes in, gets a signing bonus and a significant salary and access to proprietary data and finds himself or herself on the wrong end of a claim of improper behavior and gets dismissed, suddenly what that person negotiated for and what the company thought it had should be disrespected because this is not a collective bargaining agreement, just a personal service agreement.
Do you want all of the Wall Street places to be unionized and then you deal with that? I mean, I think it's a very, very different kind of arbitration. You have management and labor appearing before the same arbitrator. Often you have a collective bargaining agreement, it's one agreement. I think it's totally different.
All right, we might get back to this a little bit, and Wayne, I'm gonna suggest what we might get back to it on, and that is those claims like wage and hour claims that are simply not viable on an individual basis. I think that may be one of the sea changes that Ron was talking about, but our last topic is wage and hour, so maybe we can hold off till then.